Hello everyone. The topic of the paper presentation is Implication of Other Legislations on Negotiable Instruments, a study in the light of Negotiable Instruments Act 1881. The paper ID is 2040056 by Soni Kulshrestha, Associate Professor, Arun Dev Pareek, Assistant Professor, Katha Mathur, Research Scholar, Khushbu Sharma, Research Scholar. As far as the purpose of the study is concerned, the study focuses on the applicability of other legislations on negotiable instruments, which are principally administered by the Negotiable Instruments Act 1881. The objective is to make a well-established nexus among various provisions of civil, criminal, and procedural laws administering the negotiable instruments in India. The research is conducted on the secondary data, which includes the legislative enactments, a thorough study of the laws of negotiable instruments and evidence law, law of contract, and the Reserve Bank of India Act, etc. As far as findings are concerned, it is found that the principal act which governs the negotiable instruments in India is not exhaustive enough in itself. Moreover, in the matter of contradiction with other legislations, other laws supersede the Act of 1881. It gives the need of enacting a totally new enactment or to do major amendments to cover the gap or contradictions. The study reveals the deviation of principles in terms of interpretation of the provisions from the mother acts. The research is helpful to the enactment of the new amended legislation on negotiable instruments in India. It is also helpful to the researchers to understand the applicability and limitations of the present act. The research has covered the most untouched area of the negotiable instruments, which creates the illusion of the implications of the provisions of the Act when this is superseded by other legislations. An endeavor is made to make sense of the demand of a new enactment. In the introduction part, as far as the commercial dealings are concerned, in day-to-day commercial dealings, all the transactions are not placed in terms of money. There are very many different factors as well. They play an equally important role. With the expanding commerce and trade, the increasing calls of money might not be matched merely with the exchange of money. Under certain circumstances, the business person does not have ready cash with him/her. Moreover, he may not like to carry huge amount of money in his pocket at the time of traveling. Due to these reasons, the business adopted a new method of exchanging documents, and these documents, which are used as substitute for money, are known as negotiable instruments. In India, the legal provisions concerning to the negotiable instruments are confined in the Negotiable Instruments Act 1881 and in the Amendments Acts of 1988, 2002, 2015, and 2018. As far as analysis of the provisions of the Act is concerned, the researchers have identified few provisions of the Act which needs further clarifications or reframing for prolonging the significance of the Act. Just because of the loopholes, the present Act is not so much significant. Following are the provisions that need to be focused upon. First comes the definition of the negotiable instruments. Second comes classification of negotiable instruments. The third one is presumption of consideration. And the fourth point is inchoate instruments. As far as the definition is concerned, there is no specific definition there in the legislature. In the Act, the term negotiable instruments has not been defined by the legislature, which always gives the scope of various judicial pronouncements and interpretations, which may vary case to case. Just because of this ambiguity, the law has turned to be insignificant. Besides giving the definition of the instrument, the Act refers it under three kinds, such as a promissory note, bill of exchange, or check. The gap is between the provision of this Act and other laws prevailing in India. Indian law recognizes several instruments as negotiable instruments which are not covered under this act, such as hundi isn't covered, share warrants even as well, dividend warrants, railway receipt, banker's draft, and the circular notes. So a revision has to be done in order to make the present act significant. As far as classification of negotiable instrument is concerned, the Act suggested various classifications of negotiable instruments, which includes point 1, bearer instruments, point 2, order instrument, and point 3, demand instrument. The analysis of all the definitions reveals that a promissory note and a bill of exchange may be number A, payable to order or to bearer. Number B comes payable to order on demand or payable to bearer on demand. To explain further, the gap or the contradiction is between the provisions of this act and the provisions of RBI Act. The Reserve Bank of India Act 1934 restricts the issue of demand bill of exchange and promissory note. As per the language of the act, if I quote the language of the act, what we find here is no other person is authorized other than the bank or central government to issue any bill of exchange or promissory note which is payable to bearer on demand. So such points to be fixed. Then 2.3 presumption of consideration is concerned. As per section 118 of the Act, the court has a presumption, that is the presumption of consideration attached with every negotiable instruments. It means this need not to be proved by the person who holds the negotiable instruments until contrary is proved. In various judicial pronouncements, the court recognizes a bill of exchange or promissory note which was made without consideration. These kinds of bill of exchange or promissory note are called accommodation bill or note. These kinds of negotiable instrument may be drawn in urgent need of money which can be raised by a friend without any valuable consideration. The gap is about section 118 and section 43 of the Act. Those are prima facie contradictory. One recognizes consideration as presumption, second enforces the instrument which is without consideration. Again, the term here, as far as the term is concerned, accommodation bill or note is missing in the definition clause, classification, or from any explanation clause of the Act. As far as 2.4 inchoate instruments are concerned, section 20 of the Act lays down the provisions related to an inchoate stamped instrument. As per the language of the section, the Act clearly indicates the instruments, those are stamped, and in the Act there are only two instruments which are stamped, that is a promissory note and bill of exchange. The gap is many judicial pronouncements recognize or consider a check as inchoate instrument if it is lacking one or two essentials mentioned in the characteristics of the negotiable instruments, irrespective of the fact that the check is not a stamped document or there are a number of differences between the documents recognized by the section 20 of the Act in the check. As far as conclusion is concerned, beside the provisions mentioned in the research paper, there are a number of other provisions which need improvement, rectification, or clarification. Ambiguity in the language of the Act gives the scope of several analyses of the language of the section, explanation, and proviso. It imposes the extra burden on judiciary to interpret the contents of the Act, which may differ from case to case basis. The Negotiable Instruments Act is a central act, but if there is any contradiction of the laws of this Act or the laws of the Reserve Bank of India Act mentioned in the research paper and discussed in detail, the later will prevail. Thereafter, it is the failure of the legislature to give dissimilar acts which are curtailing or limiting the existence of other acts. Certain suggestions are made, and if those suggestions are followed, definitely all the problems can be fixed. As far as point 1 is concerned, in the opinion of the researchers, enactment of the Amendment Acts is not sufficient in the current scenario, because there are very many loopholes, and these loopholes or these problems should be fixed. There are very many other acts and the other laws should be kept in mind. As far as point 2 is concerned, there is a strong need of reframing of the laws related to negotiable instruments, keeping in mind all other laws, customs and usages governing these instruments. So as far as the other factors or other laws are concerned, those should be kept in mind while making the amendments or while fixing the issues. So that is the reason why the present Negotiable Instrument Act is not so much effective. The researchers suggest the enactment and enforcement of new negotiable instrument to be free from existing breaks. As far as the third suggestion is concerned, the enactment and enforcement of new Negotiable Instrument Act to be free from any existing break. It should be flawless. As far as the part is concerned, if the points are followed, definitely we'll be having a strong Negotiable Instrument Act, and which will be very, very effective as far as the implementation is concerned. There will not be any loophole, and that will be the major promissory step to be taken by the government. The following references are there while preparing the research paper. These following references that includes certain laws as well as the books and papers which were referred while preparing the paper.